I think they're getting the presentation up here. Obviously, you see part of it right now, but I'll just take the opportunity to thank everybody for coming tonight, giving up your Tuesday night to learn a little bit more about patents and patent trolls, and for the App Developers Alliance for inviting me to speak today. You heard from a couple of attorneys already. I know on the panel you'll hear from a couple more tonight. The good news is, although I am an attorney, I'm no longer practicing as one. I do business development for RPX, which is a corporation. We're right down in 1 Market Street. What we do is we try to prevent patent troll litigations by buying the very patents that they would otherwise purchase and use to fuel these litigations. In order to do this, we need to have a pretty good idea of which patents are the risky ones and approximately how much we should be paying to purchase them. And in order to know that, we have to do a lot of analysis and a lot of data collection on our side. So today I'm going to hopefully share some new and interesting information, some of the trends behind these patent trolls that you've just heard about and that I know that you're all familiar with. But just before that, I was also asked for the small task of completely explaining patents and the patent system. But I'm going to try to do that. I'm going to try to do it briefly, go over what a patent is, how a patent is issued, and how a patent can be used, and then, of course, abused by patent trolls. The goal of my talk, I think, is to underscore the same points that were being made earlier, that patent trolls may not, in fact, be the problem. Well, they are the problem, but they're not the source of the problem. The system is the problem. And perhaps a fix is best focused on the system itself. So if you'll forgive me, I'm going to sit down because I've got some data here that I don't want to mess up, so I'd like to refer to my notes. I'll stand up for the Q&A. They've given me 20 minutes. I'm going to try to move through this briskly and hopefully give us about 10 minutes of time for questions. So first of all, what is a patent? Basically, a patent is about owning innovation. The actual right itself is a right to exclude. It's the right to exclude others from making, using, or selling the idea that is described in the patent. It's a legal 20-year monopoly that is granted by the federal government and guaranteed by the Constitution. It only has effect in the United States, but of course other companies have their own patent systems that are somewhat roughly similar. So why would the federal government decide that it was a good idea to allow some people to own innovation? The idea has been that it is an exchange. In exchange for telling the entire world about an innovation and how to make and use it, people are given a limited protection to do it alone. It's supposed to incentivize development and research and investment in those areas. Now, this may seem a little bit dubious to you in the room. I doubt that most of you were motivated by a patent to start the companies that you have done. It probably, it was probably just an idea that you thought that the market was going to bite on. But this is actually fairly effective in different industries. Think about pharmaceuticals. We're developing a new drug, maybe a $100 million investment. In those areas, they really want to protect their rights, and the patent system actually functions pretty well for that. For app developers, maybe not so much. So, moving on, a patent requires that you disclose the inventors, related patents and applications, references that were considered when or to be considered when the patent office decides whether to issue a patent or not, and a brief abstract over what the patent covers. You're required to give some figures and specifications. The drawings here are actually from a real live patent, and they're a pretty good impression of what's required whenever code is involved, which is people tend to use flowcharts. The specification is a natural language description of the background. Basically what you need to do here, and are required to do, is tell the patent office what it takes to recreate your invention for a person in your field without too much work. But of course this is the body of the patent, but this is not what you in fact own. What you own is what is described in the claims. This is a real-life claim. I'm going to actually encourage you not to read the entire thing. As was pointed out a little bit earlier, they tend to be obtuse and fairly arcane in their descriptions. But at the end of the day, this is what a patent covers, and this is the property right that is confirmed. In order to get a patent, these claims need to describe something that is novel. That is, nobody else is doing it or anything similar to it, and it can't be obvious to somebody in your field as of the date that you filed for the application for the patent. Now, as was pointed out, these claims are presumed valid until a court has ruled otherwise. Getting a little bit more interesting here. Okay, and this is supposed to be a build. I guess I don't think it works really well on Microsoft, excuse me, on an Apple computer, but well, we got all the basic points. So how's it get issued? First, you have an idea. Presuming you yourself are not a patent agent, you need to go and hire one. They're usually an attorney, which makes them fairly expensive, and I think the going rate for a software patent is probably somewhere in the order of like $7,000 to $16,000, depends on if you're going with a great big firm or a boutique. This patent agent will talk to the inventor, understand a little bit about your invention, and then they will put together an application that looks roughly like the patent that we just looked at, and then they file it with the sort of blue building there that's supposed to represent the United States Patent and Trademark Office. It's initially assigned over to an examiner, and as we saw, there's a tremendous backlog. So as a patent applicant, you can kind of expect to wait a year or more before the examiner is going to have the time and resources to look at your patent. Now, an examiner has the tools to do a prior search on their own, but for the most part, they're looking for evidence that this isn't in fact, novel or obvious, using the prior art that the applicant themselves provide. You can see the problem there. Now, they do get a bonus for every rejection, so if you file a patent, you should sort of expect to get rejected at least once, at which point you have to go back to your patent agent, either limit the claims to avoid their argument or to argue successfully against them. There's a lot of hard work that they do, but at the end of the day, they also get a bonus for issuing a patent. They also have a huge pile of to-dos, and one way to reduce that is just to issue the thing. So most of the time, we see them get issued, and then you're left with a valid patent. Obviously, this is all fairly high level, but all the major parts are here. So once you have a patent, what can you do with it? And I think it's going to start to get a little bit more interesting from here. You can use a patent to defend your company. The first thing you can do is use it to keep competitors out of your product areas. It is, after all, a legal monopoly. This is, in essence, what Apple's trying to do with Samsung right now. Second thing you can do is a patent can be used for a cross-license, and this is actually a lot sexier and more interesting than it sounds on first blush. Some of you may have already had the experience, but fairly large companies tend to have very large patent portfolios, and oftentimes what they'll do is when they see a company enter into their space that's enjoying some success, they'll reach out to them with a very friendly reminder that they probably need to pay them a licensing fee. And these are operating companies. I mean, IBM will do this, Microsoft. This is standard practice. If you have a strong patent portfolio of your own, this is a tool you can use to reduce the amount that you need to pay to them. Or, God forbid they file litigation against you, you can counter-assert it against them to hopefully make it go away or reduce the settlement amount that you might eventually pay. Finally, you can use them to prevent litigations. Think about it. If you go out there and you file a patent on what you're doing, hopefully it prevents other people from doing exactly the same thing. But a patent can also be monetized. Probably the way that most of you would think of doing this is that investors are more eager to invest in the company that has a patent portfolio. Why? Well, it increases the chance that you can protect your product and your market share, and therefore it raises the valuation of your company. But of course you can turn around, you can do exactly what, say, Microsoft and IBM are doing and license your competitors and bring in some revenue that way, if you're not interested in being the exclusive player in a particular space. And then finally, you can divest your patent. And I want to stop here because this is very important. Oftentimes, in the event that a company doesn't make it, or that you don't want to enjoy one of these other options here, companies will look to sell their patents. They can be sold, sometimes for a lot of money. It is an asset, of course, and as an asset, its whole value is in its ability to make money. There is an operating secondary market for these patents, a whole slew of people who buy and sell patents. And this, in fact, is where patent trolls are born. We're going to look a little bit more into that in a moment. So now that we've seen, now that we've understood the patent system, let's understand a little bit about how it creates problems. Problems with patents. So patent trolls are obviously what we're talking about here, and obviously the panel following me will be looking into this in a little bit more depth. But before they do, what I want to encourage you to think is that trolls are really just the tip of the iceberg. Below the surface, there's a whole malfunctioning system that creates these loopholes that they're really exploiting. And if you understand the systems and the factors that are driving it, then you can start to anticipate a little bit about the activities of these NPEs. So what are some of these factors? The first one is, of course, poor gatekeeping at the US PTO. We've got overwhelmed, unprepared examiners issuing a lot of patents that they probably shouldn't be issuing. They tend to be overly broad, they tend to be weak, they tend to overlap one another, and honestly, they're likely invalid, but it's going to take a jury or a judge to invalidate it. Now, of course, a weak patent itself is not a problem if they stay in the hands of operating companies. The problem is that they don't. 76% of patent litigations filed by patent trolls were using patents that they either purchased or were at least offered for sale prior to the litigation. What this means is that all these litigations began on this open market, and most of the time, a patent troll letter, if you receive one, those patents were purchased just to sue you. Secondly, there are literally hundreds of thousands of patents issued to spaces relevant to application developers. We'll go over that in a little bit more in a minute. Third, NPEs will exploit standards and other technology bottlenecks. Now, most companies that support, say, an internet play are using a somewhat standard mix of features. We're thinking about things here like sign-in, geolocation, social features, payment, and the rest of it. What you can expect is when a lot of people use a given feature, there are going to be a lot of patents on it, and that a single patent has a capacity to sue a large number of companies at the same time, making it very attractive to patent trolls. Fourth, assuming your product supports an internet business, it's going to be public and highly visible and accessible. That means an NPE can go onto the internet and figure out roughly how the thing functions. Compare this to, say, a semiconductor lawsuit which requires about a $100,000 chip teardown before you can do your reasonable investigation and file. Fifth, even if you wanted to be a good citizen and avoid a patent infringement case, you really cannot do it. To avoid infringing a patent, you need to know about the patent in the first place. But software and business method patents, they don't have an index, they don't have standard search terms, so they're incredibly hard to filter on the PTO website. And even imagining that you could take the hundreds of thousands and filter it down to just a couple hundred, at $500 to $700 an hour with an attorney, you can quickly understand how it might just be impossible for all but the richest companies to do a complete gap analysis in the space. What that means is that you're probably walking into a minefield. So what we've covered here is that there's just a ton of weak patents that are being sold to trolls. Still though, this is not a huge problem if they were cheap to invalidate. Obviously, they're not. On average, it costs $3 million to get through trial and invalidate a patent. Now, this is not a pretty picture. But let's look at these factors a little bit more in depth, and then we can see what the end result has been. So if one of the factors driving NPE growth has been the abundant supply of patents, how abundant is that supply? So this is just looking at class codes in software, e-commerce, and media content, because, frankly, e-commerce, anything done online, this is a software patent after all, same thing with media content. We're looking at 400,000 plus issued and would be alive just since 1992. If you look at a little squiggle line, you can see notable spikes in issuance around the .com era, then again in 2006, right after YouTube was sold to Google for $1.6 billion. Now, each one of these patents represents a potential litigation. But of course, potential doesn't mean a patent troll case. If most patent trolls are buying the patents that they're later asserting, the patent needs to be sold and bought to become a problem. So what we have to look at is the liquidity of this market to understand the actual risk. And this up here is what RPX has seen over the last 5+ years in terms of brokers and other people shopping patent portfolios. This doesn't represent individual patents, this represents total portfolios, which can vary in size between 1 and several hundred. As you can see here, it really is off the chart. In fact, just to make it meaningful, we just narrowed it down to software. On the right-hand side, you can see the breadth of some of these assets that are being shopped around. Now, we estimate, in year-over-year it varies slightly, but it's about 20% of these end up transacting, and a lot of them end up with patent trolls. One question you might ask yourself if you're looking at this is who is selling these patents? Well, the answer there actually is in this room. If you look around you, what we've seen is that the vast majority of the patents that end up fueling patent troll cases come from operating companies. They're selling out their patents to raise capital. So the next question is, who's buying? Well, the answer is patent trolls. Patent troll is actually a term that was coined in 2005 by Peter Detkin, who was then at Intel, to describe these entities who use patents solely to raise money. Ironically, Pierre Decken later left Intel to become a patent troll himself, which probably shows just how lucrative this business is. Now, the PC term is a non-practicing entity, or NPE. It captures the fact that they don't make, use, or sell any of the goods related to the actual patent that they're asserting. But the main points to take away are that they are a business, their business is asserting patents for money, and their business is particularly effective because they cannot be countersued. That's because they don't actually make or do anything. They're usually just a mailbox in Texas. Now that said, they are savvy, sophisticated business entities. Many of these NPEs are run by MBAs, not JDs. Okay, good. In fact, patent trolling is a $6 billion a year industry, and as a result, $12 billion have gone into funding them today, and there are a ton of publicly traded NPEs like Acacia, Wyland, and Mosaic. NPEs commonly promise their investors about a 5x return on their investment, making them somewhat like an evil startup. And they do this, of course, through patent litigation. Finally, the model works because, as we went over a couple of times, the patents are presumed valid after it's issued, and the only venue currently for determining the actual value of that patent is the US court system, which certainly isn't built for efficiency. Here's how they work. Obviously, as we went over, 3/4 of the time, the troll in question is out there buying the patents that they're going to use to sue you. We're talking about auctions, bankruptcies, brokers, failing companies, and the like. What kind of patents are they buying? They're buying broad patents. They read on industry standards, allowing them to sue as many people as possible. Once they get them, they use this to divide and conquer operating companies. It's all about taking advantage of a basic asymmetry. For them, it's fairly cheap to fuel litigations. It's maybe 5 or 6 figures to buy a patent, $350 filing fee. They don't pay their lawyers. They've got contingency counsel, so they're using your money to do that. They don't have any documents to produce. They don't have anybody to depose. On your side of the equation, on the other hand, you have an extremely expensive court case in front of you. You're going to lose key employees for days at a time, and you've got a lot of expensive documents that you might need to produce, not to take into account that you might actually lose. So you ask yourself, what's been the effect of all this? And here you go. In 2012 alone, those 433,000 issued patents resulted in 1,021 NPE litigations against almost 2,000 unique software, e-commerce, and media distribution companies. 55% of these NPE lawsuits are against companies making less than $10 million a year. So really, it's the little guys that are fueling these numbers and these trends. And just to explain, what are we really looking at here? An NPE doesn't